Good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for August 6, 2025. All matters being heard today are being heard in accordance with all emergency orders and directives. Regarding remote proceedings, Mr. Nanias, would you call our first case, please?
Yes, ma'am. One, calling cause number 2024 DCV 2991, Bike Dreams Group LLC versus EPT Real Estate Inc. et al. Announcements, please.
What's going on with your audio, Mr. Nanias?
I'm not sure, Judge.
It's very muddled. All right, it's 2024 DCV 2991, Bike Dreams Group versus EPT Real Estate Inc. and the broker company. May I have announcements, please?
Robert Fuel, Your Honor, for Bite Dreams and Webitron and a couple of the other third-party defendants whose names I don't remember, unfortunately.
Michael Cabot, Your Honor, along with Austin Jones. We represent Lumen Technology Services Group. We were added as a third-party defendant, and we've got a motion to quash set.
Correct.
Your Honor,
Jim Scheer.
I'm sorry, Jim, go ahead.
Michael Shane and Jim Scheer on behalf of EPT Real Estate, Your Honor. Ready.
Thank you. And I thought I had printed out that motion to quash while we were waiting yesterday. I did, thought I had printed it. I know I had reviewed it. So we are set for a final status conference and a hearing on the motion to quash. Mr. Cabot, did you want to proceed on that?
I'd be happy to, Your Honor.
Yes,
thank
please.
you and good morning.
Good morning.
Yeah, so this is a case, it's a dispute between a landlord and tenant about who's responsible for paying electricity service under the terms of a lease. My client Lumen is neither the landlord nor the tenant. Instead, it provided, high-speed internet and telecommunications services to the tenant in the building, Bike Dreams. And so, as Your Honor knows, this case has been on file, about a year. About 11 months after filing its answer, EPT filed a First Amendment cross-claim and third-party petition where it purports to add my client, Lumen, as a third-party defendant. And it's asserted claims against Lumen for trespass and conversion of its electricity. Your Honor, we filed a motion to quash the citation because Rule 38 is clear that a defendant that seeks to file a third-party petition more than 30 days after filing an answer must obtain leave of court. And EPT did not do that in this instance. And, they filed their answer back on July 19th, 2024. And so the deadline for them to have joined us, without leave would have been August 19th. They didn't do that. Instead, we've been joined and we've got a trial set in October 1st, which is obviously problematic from my client's perspective. We cite some case law, what's the remedy if Rule 38 isn't complied with? It's clear that, striking the claims against the improperly joined third-party defendant is appropriate. We filed a motion to quash. Obviously that would be without prejudice to refiling. So our viewpoint is, if they want to assert these claims, they can sue us in a separate lawsuit if they want to. And that'll avoid this issue of having us joined as a third wheel 2 months away from a jury trial. And so that's sort of the main argument. It's pretty straightforward. There's also another issue because Rule 38 and third-party defendants really just pertain to contribution and indemnity claims. And, the rule is clear in Rule 38 that, a defending party as a third-party plaintiff can cause citation and petition to be served upon a person not a party to an action who is or may be liable to him or the plaintiff for all or a part of the plaintiff's claim against them. So here, EPT's third-party claims against Lumen don't suggest that Lumen is liable to EPT or Bite Dreams for all or a part of Bite Dreams' claims against EPT, rather they're independent trespass and conversion claims. So I think you also have an issue of, leave of court wasn't obtained. Now we're 2 months away from trial, and my client hasn't had a chance to do any discovery, take any depositions, prepare any defenses or dispositive motions. And in addition, we think a third party claim just technically isn't proper either under the rules. So, what's the bottom line? What do we think Your Honor should do? We think, you should grant the motion to quash, dismiss the claims without prejudice. EPT wouldn't be prejudiced as far as, it could refile its claims against us if it wants to pursue those. I don't know how, to the extent the parties want to keep the trial date, but, a dismissal without prejudice with respect to our claims would sort of at least eliminate the issue of us being joined late in the instant lawsuit. So that's what we would suggest. Alternatively, if the court denies the motion, we obviously would need to push all the dates, the trial, enter a new docket control order. I've conferred briefly with counsel with respect to that as well, and I don't think they're opposed to that. And I think that's something we could agree to. But again, our position would be that, the motion should be granted. It's pretty straightforward that the rules weren't complied with here. And, they're in place to sort of prevent these types of situations where you've got a party coming in the 11th hour in a case that's set for jury trial at the beginning of October, and we haven't had a chance to meaningfully participate in any way in discovery. So, we would respectfully ask that the motion be granted. And, as far as the final status conference, I realize sort of our motion impacts that, but obviously I don't have a lot to add with respect to the final status conference items of discussion. So
Thank you very much. And yeah, that was consistent with what I read. And I remember because I keep clicking on this answer that was filed on the 25th, thinking it's an answer to the motion to quash. I did not see a response filed to the motion to quash. Mr. Shane, Mr. Sheriff, is there a response?
Jim, you're muted.
Oh, I didn't even see that. I was looking at Mr. Shane because I thought he was frozen. Okay,
Yeah.
we're so still. Okay.
Thank you, Your Honor.
Sure.
Yes, may it please the court.
Yes,
We
sir.
did file a written response. I'm reading it right now. Cross plaintiff's response in opposition to cross defendant Lumen's Technologies motion to quash citation. And it did a great job. Mr. Chip Orr, who's our briefing attorney for me here at this law firm, Share Law, he wrote it up. Chip, formerly was staff attorney for the Texas Supreme Court. And then he was staff attorney at the two
Mr.
Dallas courts.
Let me stop you right there because Mr. Orr was in the waiting room, and so I just brought him in. But I do want to check with our clerk to see. Do you see that, Mr. Medina, the response?
Well, I do not see a response filed. I
Yeah.
don't have anything in paper either.
Yeah, there's nothing in the e-file. If we can, and the only reason I asked is obviously I would like to review it. If you have a copy handy, just know that the clerk does not show that it has been e-filed. If you would please email it, I would like to see that, but I'm happy to just continue with argument. And I don't know if counsel has received the response either. Okay.
I showed it was filed. My certificate of service signed off by me was July 23rd, 2025. So, and Mr. Orr is in, if he need, I'm going to just use his brief and respond to it. But before I do, let me talk to you about the, where we're at on the underlying case. Mr. Fuel and myself and Mr. Shane have had numerous discussions, and we have given, there've been no depositions taken. Paper discovery is just beginning. We've asked Mr. Fuel to go back and get supplemental discovery responses on it, which he's agreed to do. Those supplemental discovery responses, I think, are supposed to be due back to us by August 31st. So none of us are, neither Mr. Fuel nor our side are ready for trial on it. And we have talked previously that we agreed to have a new time set for trial for this matter and move our deadlines back if you will permit us to do that, because we're just in the infancy stage in processing this claim. And there's a lot of reasons for it. But we've been diligent in moving it forward. So to give you that heads up, if Mr. Fuel disagrees, if he wants to say anything, he's welcome to do so. But I think it's been very cordial and appropriate to try to move this case forward.
We've been
Uh-huh.
struggling around, Your Honor, with discovery issues and trying to get to everybody the discovery that's needed, and that's been part of the holdup. So I think everybody's in the same position that we need to ask you for a new trial date.
Okay, and I get that. Is there anything on the motion to quash? This is what I think I would prefer to do. Understanding that the response is outstanding, I'm happy to consider that via submission, and I can do that very quickly this week. I think however we get there, we're not looking at an October 1st trial date. I mean, October 3rd jury trial date. So if you all are in agreement, then what I would like to do is cancel the final civil pretrial that is scheduled for August 27th. And we're going to utilize the October 1st docket call date as now a scheduling status conference so that you all can let me know what kind of timetable you're going to need going forward, kind of with this little window through October 1st to see how things move along, and also in light of the motion to quash. So I don't know, Mr. Scherer or Mr. Orr or Mr. Shane, if you had anything in terms of the response. I'm happy to hear it now, but I'm also happy to, once received, review your response.
Well, we would like to just briefly respond
Yes,
so
sir.
that Lumen gets in this case and they move forward with us jointly on discovery and we move the case forward. Let me explain why Lumen was brought in and what's going on. EPT owns an office tower on the far east side. It's the tallest building on the east side. It's 1790 Lee Trevino. Webitron was a tenant in the building. They rented a very small space in the building, and they were an internet provider to various companies. Unbeknownst to EPT Real Estate, Webitron entered into some agreement with Lumen. They put antennas on top of the roof and they plugged into the building's electricity, so that EPT, unbeknownst to it, was because they plugged into a mechanical room or electrical room without notice and put their computer stuff, all these electronic equipment in a closet and hooked in using the EPT Real Estate's electricity. That's what the lawsuit's about and why Webitron got sued. Webitron and these other companies that Mr. Fuel represents were all, somebody else bought them out. That's when it became apparent that there was something going on during the process, or something happened there. And then it was learned that Lumen, which was not even authorized to be in the building, had no agreement at all, didn't have an easement, didn't have a license, didn't have any right to be in the building at all. It had taken their plugged it in, and were using this electricity in the building for the benefit of Webitron. So the reason that Lumen was brought in to this case is because they were working with Webitron in this matter and providing them internet service and electronic service and cable service, all using the building's electricity. That's what the lawsuit's about. The joinder of Lumen was properly done. Mr. Orr's on the phone if you want to go through all the procedures. Lumen is complaining that Rule 38 doesn't apply. the 38 required a motion for leave with the court first. Well, for the brief is very good. It points out the Texas Supreme Court case of Bennett versus Grant, which was 525 Southwest 3rd, 642, page, and is 2017 Supreme Court relates quotes Rule 997F of the Rules of Procedure that allow bringing in cross claims, third party claims. Our claim is actually brought under Texas Rule 40, not Rule 38, which allows permissive joinder. And there's no requirement to ask for leave of court to add in a party whose the relief is sought jointly and severally arising out of the same transaction, occurrence, or series of transactions or occurrences, and which have questions of law and fact common to all of them. So our brief, and we'll get that to you, we're on solid ground. We feel there was no need to request leave of court on it, and it had leave of court even been requested, the court respectfully, in its discretion, would have granted leave of court, and there's no abuse of discretion to have added this defendant.
So, yeah, I think Walter's about to tell me what is happening. The audio is cutting off quite a bit. It's very choppy. So I don't know if it's a Zoom thing today, because now I'm hearing more than one person with that issue, but we're missing some of your argument, Mr. Scherer.
It may be all it's worth. What can I say?
The universe is telling me I'm going to consider this via submission. That's what the universe is telling me right now. But
I think that's correct, Your Honor.
I'll let you continue if you'll just maybe not move so much. I am not a Zoom doctor. I don't know how these things work, but maybe eliminate the cutout.
I'll stay real close to the mic.
Mm-hmm.
So the Supreme Court, Rule 40 is what we brought the claim in under. Rule 97 absolutely allows permissive joinder with Rule 40. This is not a rule. Rule 38 deals with contribution and indemnity. That is not what this claim is about. We're not claiming or requesting contribution and indemnity. We're suing them directly. And what's most important is bottom line, they've already answered the lawsuit. They filed an answer. They're in the case. Now they're asking you to dismiss them after they've already answered. We would request that the court deny their motion and let us all go forward so we can move this case and get discovery done and proceed. Thank you.
Thank you very much. I'm a little hesitant to ask you, Mr. Is it Cabot or Cabot? Cabot. I'm a little hesitant to ask you to reply to that because you were, as is the court, a little bit at a disadvantage of not having received the written response. But to the extent you have a reply, I'm happy to hear it.
Yes, Your Honor, and thank you. You're right. I haven't received a response, so I am at a bit of a disadvantage with respect to replying to the arguments. I will address, we did file an answer. It was made expressly subject to the motion to quash and was done out of an abundance of caution to prevent a default occurring because we couldn't get it set before our answer deadline. So, the fact that we filed an answer to prevent default and then just say, well, our failure to comply with the rules should be excused because they filed an answer anyways, is not, I think, the result that should be reached here. They say Rule 40 applies, which just generally talks about permissive joinder of parties if they're all part of the same transaction occurrence or series of transactions or occurrences. And, that's fine. The problem is they have filed a third-party petition and named us as a third-party defendant. And there is no question that Rule 38 applies to that. And the text of the rule is very clear and it's mandatory. Leave of court is required. we cite case law that says, well, what's the court to do if someone doesn't comply with that? You strike the claims against them, and it can be without prejudice. And so they want to file these claims properly and not as third party claims to a landlord tenant dispute. They're free to do that. And that's what we suggest Your Honor should do. And if you want to, rule via submission so that you can get the benefit of seeing the response, I don't have a problem with that. Obviously our perspective is we'd like to, know whether we're in or out sooner rather than later, because that'll impact, whether we need to do a scheduling order to push things back or not. So
Here's what we're gonna do.
Yep.
We are going to, well, we're not actually continuing it, but yes, the court is going to consider this via submission. So Mr. Scherer, Mr. Shane, Mr. Orr, I need to see that response has been filed and accepted by the district clerk, served on opposing counsel. All counsel, please send a courtesy copy via email to the court. If you can do that today, that would be great. With that, Mr. Cabot, I'm going to give you an opportunity, say by end of business on Monday, if you would like to file anything in response to that for me to consider. I wouldn't say what, I don't want to put you on a super crazy deadline, but I would like to handle this by Friday. I'll just put it like that. I would like to handle this. I don't want to carry this over. And my deadline will be Wednesday of next week to rule on the motion to quash. Okay. So that's what we're going to do.
Okay.
That doesn't change the scheduling changes I mentioned earlier, which are a cancellation of the 8/27 final civil pretrial, a cancellation of the October 3rd jury trial. We will only keep the October 1st date as our scheduling status conference.
And will that be via Zoom at 9 a.m.,
Yes.
Your Honor? Okay.
The docket call, I think, is 10 a.m. Are you out of town? So you're probably 11 a.m. The time on October 1st is the same, so it's 10 a.m. It'll just no longer be a docket call because we're pushing back that trial date, and I'm going to find out until when.
Okay. Thank
Yeah. Okay, that's what we're going to do. So
Perfect. Thank you, Your Honor.
we'll see you all on October 1st, if not sooner.
Good luck on your trial.
Oh, thank you. Have a good one, guys. Take care. Y'all are excused.
Okay.
Thank you, Your Honor.
Oh, I see Mr. Rose, and I remember writing his name down on the motion for leave on page 3, and that's at 10:30.
Your Honor, I have a 9:30 hearing, but you
Oh.
signed the order yesterday.
Yeah, I tried to, I was trying to catch up yesterday since it turned into like a nice little work day. So yes, I meant to say, I didn't realize you were going to be here on another case. Basically,
Well, Judge, that
it's
until
done.
I hear the court cancels the hearing, I show up whether I have an order or not. So
Okay, thank you so much.
but
But if that's all you have, you're good to go.
thank you, Judge. I appreciate it. Hopefully the sound gets better today.
I know that'll be not a new thing, but frustrating. Telling
Thank
you,
you, Judge.
the forces don't want us here. They want us.
Well, I know the internet was down last week or
really?
earlier this week?
Oh, that's right. Yeah, we've had some issues. It's
Yeah,
that 108-degree heat. That's what it is.
Well, that doesn't surprise me, Judge, but thank you very much. Have a good day.
You too. Bye-bye. All right, Mr. Rose, I think you're a little early, huh? Or did you have something else besides Pedro Morales?
Oh, no, I'm only here on the Pedro Morales, Your Honor.
Okay, so that's at 10:30 and it's 9:30 right now for us.
Oh, that's right. You guys are
We got our own time
behind.
zone over here.
Okay.
So,
All right. I will
frankly, unless you can wrangle up everybody and tell them to be here because you were here early, we're kind of light right now in the schedule. That's why I say it, but you're early.
Okay. I will log back in an hour then. Thank you, Your Honor.
Bye-bye. So that's all we have?
Yes, ma'am, till 9:45.
Okay, let's get off of YouTube then.
Yes, ma'am.